Hello everyone. Welcome to the third webinar of the NetProlat project. In this webinar, I will tell you about my recently published book. The title of the book is Criminal Defense at Police Stations, a Comparative and Empirical Study. But let me first tell you about the history of this book. Before coming to the academia, I was working in an international organization whose role was to promote reforms of criminal justice systems across the world. And my particular role in this organization was to work on reforms of criminal legal aid or criminal defense. And through this work, I have met with lawyers from very different countries like Bulgaria, Ukraine, Lithuania, Mexico, but also Sierra Leone, Mongolia, Indonesia. And meeting all these lawyers gave me a keen interest to know more about what it's like to be a criminal defense lawyer, what kind of challenges and obstacles the lawyers face in their work. Another inspiration for the book came from quite a different direction, and that was the process of drafting the so-called EU procedural rights directives. I'm sure most of you know that now we have 6 directives of the European Union on the various procedural rights of suspects and defendants in criminal proceedings. Now, myself and my organization, we were quite closely involved in the process of negotiating these directives. And now, from September this year, all the 6 directives are in force, so they apply in most member states. These directives do not really create any new rights, but they do create expectations on the member states to guarantee and to uphold the procedural rights of suspects. And they do also, in my view, they create expectations on criminal defense lawyers to uphold these rights, because it is first and foremost a criminal defense lawyer whose task is to advance and to protect the rights of a criminal suspect. So in my research, I wanted to compare those expectations that are placed on lawyers by the new EU procedural rights directives, but also other European standards, national legislation, professional standards, and the everyday reality of criminal defense work. So to what extent is this ideal role is reflected in the daily practice of criminal defense lawyers? I could not focus on the entire criminal proceedings because that would be too much work. So I decided to concentrate upon one stage, which is the investigative stage, which begins with an arrest of a suspect and involves the first interrogations of the suspect by police or other institutions. So in my research, I have focused on 2 European countries, the Netherlands and England and Wales. England and Wales is not a country, it's a jurisdiction. Why these 2 jurisdictions? Because they have the most developed, the most advanced systems of legal aid, and particularly criminal legal aid, in Europe and possibly in the whole world. So these 2 jurisdictions, they are cited as examples, as good examples of well-developed systems of criminal defense. So my expectation was that, in fact, they should be compliant with the expectations of the EU procedural rights directives, and I could perhaps use those examples as evidence of best practice. Now, my findings were actually quite different. I have observed a large gap between the ideal role of a lawyer implied in European regulations, national regulations, and the everyday reality of criminal defense in both jurisdictions where I did my empirical work. Now, to give you just a few examples. In the Netherlands, for instance, there is an expectation which is embedded in law's professional standards, national legislation, legal tradition, which is also backed by the case law of the European Court of Human Rights, that there should be a high level of trust between the lawyer and the suspect. And the existence of this trust is presumed, and all activities of a lawyer are based on this trust. Now imagine a Dutch lawyer goes to the police station. Usually the client doesn't know the lawyer. The lawyer gets very little information about the background of the client or what he or she is suspected of. So it is difficult to imagine that that in these circumstances there is a high level of trust between the suspect and the lawyer. The existing European regulations, and I developed this point in quite some detail in my book, they create an expectation that a lawyer would act as a safeguard of a so-called effective participation of the suspect in criminal proceedings. And effective participation, that means really a lot of things. That means being informed and being aware and understanding your procedural rights. Understanding on what is at stake, knowing about the procedures and the development of the procedures, being able to take informed decisions about your defense, and especially the most important decisions such as what to say or what not to say to the police, or what kind of statement to make in court. It also means being able to control and to lead your defense and to develop an argument against the allegations made by the state. Now, the question is whether criminal defense lawyers as a profession have the capacity or are equipped to be the guarantors of effective participation of suspects in criminal proceedings. And based on the outcomes of my research, the answer is no. I don't think that lawyers in the current conditions in Europe are capable or able to be the only or the foremost guarantee of effective participation and other procedural rights of a suspect. Another question is whether lawyers should be given this role. There is a tendency in many, certainly Western European states, but I think other European states as well, towards the reduction of welfare state. So the states they withdraw from the areas where they traditionally they have been really quite active, such as social security or upholding social rights, but also upholding fair trial rights. And we observe this tendency now very clearly in the current reform of the Dutch Criminal Procedure Code, that lawyers are given sole responsibility for enforcing the rights of criminal suspects. So if the lawyer does not advance or does not claim the right, then there will be no one in the system who would defend or protect the right of a suspect. And that, I think, is quite a worrying development. Coming back to the findings of my research, I have documented a number of challenges or obstacles for lawyers that prevent them from being the safeguards or guarantors of their clients' effective participation in the proceedings at the investigative stage. And I think one obstacle which is quite universal across the systems is what I've talked already before with respect to England and Wales, is the tremendous power imbalance between the police and other state authorities and defense lawyers. So the pretrial proceedings, and particularly proceedings at the investigative stage, they are designed in such a way that the authorities have all the control. They have tremendous powers. They have informational powers because they lead the investigation. They have psychological powers, they have coercive powers because they have the right to detain the suspect for quite some time before trial. And there is no neutral arbiter, there is no third party who would try to intervene in case there is a debate, a discussion between the defense lawyers and the suspect on one side and the authorities on the other side. And in fact, the authorities, the police, the prosecutor, take a decision mostly at the pre-trial stages, and that is very different from the trial where you have the judge and both parties present arguments to the judge. So the procedural design of the pretrial stage is very different, and therefore one can come to a conclusion that to what extent or whether it is possible at all within the existing procedural design, whether lawyers at all are able to effectively defend their clients, or do we maybe need reforms of the whole structure of the criminal justice system in order to give this opportunity for lawyers to effectively defend their clients during the investigative stage. Another quite common obstacle, which also manifests itself in a number of European countries and beyond, is the financing, the money problem. As I've said before, traditionally the Netherlands and England and Wales, they've been quite generous with criminal legal aid funding. However, in the recent years, and especially in the last 20 years, and most recently since the times of the financial crisis of 2008, the legal aid funding is being progressively cut. And the cuts have reached such an extent that lawyers in the Netherlands, for instance, have threatened several times to stop their operation because they are financially unsustainable. And there's been cases brought to courts, including the Supreme Court, particularly with regard to financing of police station legal assistance, because that is actually this particular moment in the proceedings that is the worst remunerated at the moment. In the United Kingdom, England and Wales, we observe a very similar tendency where the legal aid fees are being diminished, gradually diminished. In both countries, there exists a system of fixed fees for police station legal assistance, meaning that lawyers receive the same fee no matter the amount of time that they invest in the case or in the interrogation or attending suspect at the police station. These fees are really rather low if you compare them to the usual hourly rates of defense lawyers. And that leads to the situation where lawyers are no longer able to give the whole plethora, the whole range of assistance to their clients, that they can only do bare minimum, which is acceptable by the system in order uh, not to become financially bankrupt. Another worrying tendency is something that I have briefly outlined in the beginning of this presentation, is the trend or the tendency towards managerialism in the criminal justice system. Now, managerialism is a British term. It comes from the British Conservative Party. And that simply means that the direction in the general government policies, but also in policies on criminal justice, to save resources and to manage the systems effectively, or supposedly effectively, to introduce all sorts of bureaucratic steps and bureaucratic checks on the system, and also being very careful about so-called cost efficiency of the system. These trends are also present in other European countries, not only in the UK, even though the term managerialism comes from this jurisdiction. And this managerialist reforms in the criminal justice system actually mean that there is less and less space for lawyers to do their work, because states try to save money, they try to save costs, they try to render the proceedings less time consuming, less costly, and that means that lawyers might not get the opportunity to make a counter argument, or to participate in the proceedings in an effective way. So the last point, or the one before last point in this presentation I wanted to make concerns lawyers' professional cultures. Professional cultures have been defined as the underlying beliefs of the profession that are taken for granted by its members. They've also been defined as the values that the profession develops, or the traditions, the behaviors that the profession develops in response to the common so-called existential threats to the profession. So the most serious moral dilemmas or challenges in the exercise of the profession. And I think for criminal defense lawyers, there's actually quite a few this kind of obstacles or challenges. One, which is quite obvious and which is really universal, I think, across all legal systems, is this dilemma of criminal defense lawyers of defending the underdog and defending suspects who are probably guilty, who are marginalized, who are not the approved, not the accepted members of the society. So lawyers are often being asked this question: so how can you actually defend someone like that? And that, from the perspective of professional culture, that does create dilemmas, that does create tensions in the lawyer's role. And lawyers have to deal with this tension. Another obstacle or challenge, which again I think is something inherent in the criminal defense profession itself is this the need to oppose, or the need to fight the whole machinery of the state. The lawyer is the only person who is there for the rights and interests of the suspect, and the whole machinery of the state is on the other side, and it's trying to destroy really the argument that lawyers might bring, and that also creates a tremendous amount of difficulties in the exercise of criminal defense profession. But my point about professional cultures was the following. Every profession, and teachers or academics are not an exception to that. Like academics, for instance, the challenges that they face is that they have to explain to the general public why they spend why so much money is being spent on their salaries, and they don't produce any tangible result. But every profession has developed certain responses or certain behaviors in response to this kind of challenges. And I describe the kind of behaviors that I have noticed on the side of lawyers at this particular stage of the proceedings. Of course, I couldn't observe their entire work, so I can only talk about the very early stages, and their interactions with the police and their interactions with clients in the very beginning of the criminal case. But lawyers have also developed some sort of responses to those dilemmas and challenges. And these responses to the dilemmas and challenges, they are not always something that lawyers really think about or that they really consciously reflect on. They are just being applied as the common reaction, as the flight reaction, as it were, of the entire profession. For instance, one common thing that I've noticed when spending lots of time with lawyers in both the Netherlands and in the United Kingdom is the very particular type of attitude to clients, that lawyers really tend to be rather in the first instance to be rather mistrustful and to guard themselves against what the clients say, because there is no way for them to know whether clients are telling the truth or not, and if they don't, and if the lawyers then go ahead and assert certain things on behalf of their clients, they might suffer repercussions. They might suffer loss of professional reputation. But it's interesting to see that these reactions and behaviors are rather common across jurisdictions, and they, in the end, they do have a impact. They do have a influence on how and whether lawyers can, in fact, ensure effective participation of their clients in criminal proceedings. So the very last point that I wanted to make today is the importance of training. Most of you, of course, know that in the Net Prelat project we develop training for lawyers particularly on assisting clients at the early stages of the criminal proceedings. We have in the past developed supralat training, which was the predecessor of net pralat training, and that training was actually based quite a lot on the outcomes, the findings of my research. So why training is important? There's two reasons. One reason is the training is needed, in my view, to empower lawyers to perform their tasks, to perform their work in the best possible way within the existing obstacles and in the existing imperfect reality of within which they exercise their profession. So they give lawyers tools to feel more confidence, more certainty about what they do and what they can do given the different all sorts of limitations that exist. And the second reason for why we have developed this training is that this training helps to address those issues in professional culture that I have been talking just before. The training helps to for the members of the profession to uncover those assumptions and those behaviors that were taken for granted, that were assumed to be correct because most of the profession, they act in the same way. So in our training, we really help lawyers to become aware of their professional choices and of the reasons behind their choices. I wish to thank you for your time in following this webinar and for your interest in my research and in my book. I will organize a separate session for those of you who would like to pose questions or share remarks or observations about what you have heard today. But for now, thank you again and goodbye.